of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Barbados, hearing of appeal in BBCV number 3 of 2024 between CGI Consumers Guarantee Insurance Company Limited and Valentine Stevenson and Vincent Thomas, administrator of the estate of Shailene Ordine Thomas, deceased. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Counsel.
Madam Justice Raj Norsley.
Good morning, everyone.
Mr. Justice Baru.
Good morning.
Mr. Justice Jamada.
Good morning to everyone.
And Madam Justice Ononiru.
Good morning, everyone.
May we have the appearances, please? Thank you.
Good morning, my lords, my ladies. May it please this honorable court, I am Andrew V. Thornhill, and with me is Miss Shadia L. Hines and Mr. Koshawn K. Wood. We are counsel for the appellant. My lords, my ladies.
Thank you, Mr. Thornhill.
Good morning, my lads, my ladies. I am Verla de Pisa, and I am counsel for the first respondent in this matter, Valentine Stevenson. He is not with me this morning. He is joining us. He will follow via the live feed instead.
Good morning, and thank you, Mr. Pisa. For the second respondent.
Judge, I think they're muted. Ms. Ticharan and
Sure.
KC Cheltenham, you may need to unmute your microphones. Are you hearing us from the CCJ?
Are you hearing us?
Could you wave could you wave? Right. So I think you need to unmute because we're seeing that you're muted.
Could you put it in the chat?
Yes.
Muted. Sir Richard, can you hear us? If you can, please give a thumbs up. Ms. Ticharan, can you hear us? There seems to be a technical difficulty, Madam Deputy Registrar.
Yes, Judge, you may have to let us stand down for a minute. Let me see whether our IS can assist them. So we will adjourn for Judge, your direction.
No, can we wait for a minute or two? If it's not resolved, then we could stand down.
All right. I'll have the team, one of the team members call either Ms. Ticharan or KC Cheltenham. Just give me a minute, please, Judge.
Good morning.
Good morning.
Let's see here.
Are you hearing us?
Let's see what's going on.
Ms. Ticharan, are you hearing us?
I can hear you now, my lord.
Wonderful. And we can also hear you.
Yeah.
We were curious as to whether you wish to enter an appearance.
My apologies, my lord. I don't seem to have been hearing you throughout. Sorry.
That is fine.
Yes.
We are commencing proceedings, and we're asking for appearances. And we have got to the second respondent, and we wondered if there was to be an appearance for the second respondent.
Sir Richard Cheltenham, my lord. Casey, leading Shelley Ann Seacharan for the second respondent in this matter.
Wonderful. Thank you very much. And you have not missed anything at all. We are just now starting.
Thank you, my lord.
Okay, thank you, Counsel. And we have a very interesting case. I hope you don't mind my using a slang to say a doozy of a case. And we're looking forward to the arguments which will be presented in this matter. I know there is an appeal and there are cross appeals. So I think we have decided that we will ask the attorneys for the appellant to present your appeal and also to address the issues that come up in the cross appeal. And we will ask the same of the other attorneys who address us. There will be then an opportunity for a reply, of course, and it needs to be for a rejoinder. We thought that was the most efficient way of dealing with this matter. Assuming it's acceptable to you, may I ask counsel for the appellant to proceed?
Much obliged, my lads, my ladies. Unless this honorable court otherwise require, we do not propose to rehash the arguments that are contained in the written submissions, which are before this honorable court. Of course, feeling assured that the court is well apprised of the arguments contained therein. However, we wish to address a few issues arising in the appeal. My lads, my ladies, though the entire Court of Appeal...
Chair, with your leave, can we suggest to Mr. Thornhill that this court we are not referred to as my lord and or my lady, merely as your honors. I think that is an important matter for the public record.
Yes.
Thank you, Your Honor.
Mr. Thornhill, the thought occurred to me as well. I was hoping that corrective measures might have been taken as you went on, but I think that's correct. Probably useful for us to make that point right at the beginning so we don't slip too often. Occasionally there might be a slip, but we don't slip too often in the old language. So your honors is fine.
Thank you, Your Honors. Your Honors, though the entire Court of Appeal rejected the respondent's argument that Section 76(3) of the Road Traffic Act was retrospective in its effect, and that's at paragraph 18 of the decision. And though it held that the first respondent was not the holder of a valid driver's license on the day of the accident, at paragraph 19 of the decision, and though it held that the exclusion clause was not an unfair contract term under the Consumer Protection Act, paragraph 23 of the decision, we submit, Your Honors, that the majority of the court erred in holding that pursuant to Section 43(1) of the Road Traffic Act, the appellant's liability to satisfy the judgment debt was established. Paragraph 28 of the decision, Your Honors. And they also erred, it is respectfully submitted, in holding that the exclusion clause found in the appellant's policy of insurance does not exempt the appellant from liability to satisfy the judgment debt obtained by the third party second respondent. So the issues we propose to address orally this morning is the issue of what we refer to as the alleged retrospectivity of the Road Traffic Act, particularly Section 76(3). Then the effect of Section 43(1) of the Road Traffic Act. And lastly, the availability of the exclusion clause to the appellant to limit its liability in the instant matter. Your Honors, both respondents have placed heavy reliance on what they refer to as the retrospective effect of Section 76 of the Road Traffic Act. In the bundle before Your Honors is an extract from Binion. Can you find it? And this extract deals with the retrospective effect of legislation. And at section 7.13, the learned authors succinctly state that legislation is retrospective if it alters the legal consequences of things that happened before it came into force. Your Honors, the Road Traffic Act of Barbados came into force in 1981, and the accident occurred in 2007, November 2007. So there can be no retrospective effect of any section in the Road Traffic Act applying to this matter. It is respectfully submitted, Your Honors. I think the learned High Court judge used that term retrospective to suggest that the payment of the license fee on renewal pursuant to Section 76(3)(c) of the Road Traffic Act, and to use your words, retrospectively validated the license from the date of its expiry. We respectfully submit that to apply the concept of retrospectivity in these circumstances is to err. We may consider whether the effect of Section 76(3)(c) is to backdate the validity of the expired driver's license to the date of its expiry. You'll recall that the driver's license of the first respondent had expired in June 2007. The accident occurred in November, around the end of November 2007. And on the next business day, the first respondent went to the licensing authority, paid his renewal fee, and the High Court held that late payment corrected every defect and validated everything going back from June 2007 when the license expired.
May I ask, Counsel, that's a very quick question. Given that the fee was paid late, 2 months late, but if he hadn't been paid, would the driver then be exposed to any regulatory liabilities in respect of time when the license was not renewed?
Well, my lad, and I will answer that in this way. Were there an accident, let's say, where the first respondent charged, let's say he was found driving the vehicle and he was charged for a Section 61 offense. Section 61 of the Road Traffic Act creates an offense of driving without a driver's license, a driving license.
Yes.
So were he arrested and charged, let's say in August, for driving without a driving license, and the case is coming on before the magistrates in September, could the first respondent go to the licensing authority just before the case comes on before the magistrates, pay his licensing, his renewal fee, and validate back to the day on which he was charged with driving without a driving license?
And you're saying no?
No. There's nothing in the legislation, Section 61, Section 76, that allows for a curing of an ill that occurred during the period of the expiry of the driving license.
Okay.
Were it so, Your Honors, it would make a total mockery of Section 61 and that offense, because, like I'm positing, Stevenson could have gone and paid the license renewal fee to the authority and then go to the magistrate and said, hey, I paid my fee. What I did back in August is now cured because the license has now been validated. There would be no Section 61 offense, Your Honors, none. But Parliament could not have intended that, Your Honors. And we respectfully submit that the effect of Section 76.3, particularly Section 76.3c, and this is Section 76.3c, is where the license is presented for renewal on a date subsequently to when it expired. And on payment of the fee, the license is renewed.
Mr. Thornhill, did you mean section, just for clarity, did you mean subsection 3B? You said 3C. Just 3C. Want to make sure.
3C, Your Honor. Section 76.3b, where a driving license is renewable under this section after the expiry date specified in the license, the holder of the license applies for a renewal of the expiry on the expiry date. This is where the driver applies for a renewal on the date of expiry. But Section 76.3c is where a driving license is renewable on a date prior to that on which the license is presented for renewal. So it is renewable on the 1st of June, but it is presented for renewal on the 1st of August.
I think the example you gave us, Mr. Thornhill, is very clear and very persuasive, if I may say so. That example being one of a regulatory offense. Of course, what we are concerned with in this case is not quite that, is it? We are concerned with an issue which has entangled with it contractual matters, insurance policy, and so on. But you're using that as an explanation, a comprehensive explanation of the status of the driver's license in the circumstance you're speaking of, yes?
Well, Your Honor, if we are to find justification for backdating the renewal in cases of not the regulatory now, but the contractual, as here between the appellant and the first respondent, we have to find that justification in the legislation. And that justification has to be found in section 76, section 76 3C, which allows for late payment. But the holder shall be required to pay a license fee. Your Honors, the renewal can be, the license can be presented for renewal at any time. And
Mr. Thornhill, can I just interrupt you? So that under the statute, just going along with what you're saying, 76 3C, you have a license that has, your example, has expired on the 1st of June, correct?
Correct.
So it is now an expired license. The holder does not have a license because the existing license has expired.
Correct.
Right. If they go on the 1st of September, your date, and they follow 76 3C and pay the required fee, yes?
I'm with you, Your Honor.
Then they get, what do they get? A renewal of what they had? Or do they get a new driver's license in which the issue date is the 1st of September?
Your Honor,
what happens practically? You have a driver's license, so that if you are first time and you go, you get date of issue, expiry date, correct?
Correct.
Expiry date is 1st of June. You go on the 1st of September and you pay the fee. Is that a renewal of what pre-existed, or do you get the issuance of a new, it's called renewal, but of a new license in which the issue date is the 1st of September? What do you get?
With the greatest of respect, Your Honor, what you get is a renewal of your existing license effective from the 1st day of September.
And where does that show up on the document? So on the renewal license, if you are correct, I'm not suggesting you're not, where is that reflected on what is issued? Because your existing license says expiry date 1st of June, correct?
Correct, correct.
So you pay your fee, what do you get? Just very practically, what do you get?
I don't believe there's any endorsement on the license.
So when you say that you get a renewal effective from the 1st of September, that is not evidence on the document. On the license, is it? Or is that your supreme position of the meaning of the statute on the transaction?
That is my interpretation of the section, Your Honor. I'm looking in my mind's eye at my license, and he must have renewed it at the date subsequent to its expiry. I do not recall there ever been an endorsement.
Right. So for example, you can have a license, it expires, and 2 months, 3 months, 4 months can pass. And is there any provision that says that driving, there is an offense? I get the Section 61 offense. That's true throughout the Caribbean. You are encouraged to have a valid license, meaning one that is, not expired. But when you come afterwards and renew it, what I'm just trying to get at, in terms of the late payment, is there anything else that tells us that the late payment only makes the license effective from the date of the late payment? And that is to say, in the gap between the 1st of June and 1st of September, the status is no license, no existing license or no current license. Is there anything that documents that?
Mr. Thornhill, once you've answered my brother, unless there are any other questions from my colleagues, I'm going to invite you to move on to your second point. Thank you.
Thank you, Your Honor. And Your Honor, Justice Jamadar, I am told by my associate that you're issued with a receipt, and that receipt shows the date of payment. So the receipt given in September would have September to June. But the section says, but the holder shall be required to pay a license fee calculated on the period commencing from the expiry date. And my view, respectfully, Your Honor,
I know that we want to move on. So the expiry date would have been from the 1st of June.
From the 1st of June. So you pay in September and you get a receipt saying September.
I know, but you've paid from the 1st of June. Is that what the section is saying?
No, with respect, Your Honor, the section is saying you can present your license late.
Yes, but you shall be required to pay a fee calculated on the period commencing from the 1st of June, not from the 1st of September.
Correct me, Your Honor, because in my view, this is a revenue collecting measure, and it's to prevent drivers from cheating the system. For example, Your Honor,
Counsel, would you like to adhere to the President's suggestion? Because I think you have just captured it beautifully. This is a revenue matter. If you pay the 1st of September, the revenue will not prorate the year for which you are paying, or the truncated year, and not collect for the period 1st June to 1st September. It will collect for the entire year. So as the President suggested, this really doesn't take you any place.
Much obliged, Your Honors. So then, Your Honors, I shall address the effect of Section 43(1) of the Road Traffic Act and the appellant's liability to satisfy the judgment debt. My lords, it is respectfully submitted that both the High Court and the Learned Court of Appeal treated Section 43(1) of the Road Traffic Act much like an offense of strict liability. The approach was that there is no escaping the effect of Section 43(1). But, Your Honors, there are two cases that I will refer this honorable court to. First one is Joseph Cadet, and St. Lucia Morton General Insurance Company Limited in your lordship's bundle, and a case cited in Cadet, a Jamaican case, Meshach Willis and Globe Insurance Company of Jamaica Limited. And in both these cases, the court and the Court of Appeal in both instances had to consider the provisions of their Motor Vehicle Insurance Third Party Liabilities Act, which is identical to Section 43(1) in the RTA. In the Cadet case, there was a provision in the respondent's policy of insurance that exempted it from liability in respect of any accident, loss, damage, liability caused or sustained while the vehicle was being operated by an unlicensed driver. Of course, there was an accident. The appellant obtained a default judgment and sought to enforce it against the respondent pursuant to the respondent's statutory duty to indemnify under Section 9(1) of the St. Lucia MVIA, Motor Vehicle Insurance Third Party Risks Act. And the respondent denied liability relying on the exemption found in the policy, the exemption or exclusion clause. In her analysis of the application of Section 9 of the MVIA, Justice of Appeal Blendman, and I'm quoting from paragraphs 32 to 34 of her decision. It is clear that under the MVIA, the obligation to satisfy and ensure, the obligation on an insurer to satisfy a third-party judgment and the right of a third party to seek satisfaction of its judgments by the insurer are governed by Section 9(1). And Section 9(1), when broken down into its basic premises, is comprised of the following conditions which must be met. 1, a certificate of insurance must have first been duly delivered under the MVIA. 2, judgment has been entered against the person who is insured by the policy in relation to a liability as is required to be covered by the policy of insurance under Section 41B of the MVIA, similar to our legislation. And thirdly, the liability to which the judgment pertains is one which is covered by the terms of the policy to which the certificate relates. My lads, in the majority decision took a similar approach. The majority of our Court of Appeal, they took a similar approach when analyzing the effect of Section 43(1). And this is paragraph 27, Your Honors. At paragraph 27, the Court of Appeal stated, Section 43(1) of the RTA is the most important section in respect of third-party rights against an insurer. It requires an insurer to satisfy a judgment obtained by a third party against an insured as long as a certificate of insurance has been issued by the insurer to be insured. But then the Court of Appeal went on to broaden the effect of the remaining conditions to a judgment has been obtained against a third party, ignoring, Your Honors, the remaining provision of the legislation. It must be in relation to any liability as is required to be covered by the policy of insurance.
Yes, I think I get that point, Counsel. I suspect my sister, Justice Anonimo, may have a question for you in relation to the meaning of that term, because the reference to liability covered by the policy, there's a definition for that, and I don't know, Justice Anonimo, whether they wish to pick that point up, because I think that's an interesting point.
Yes, Chair. Counsel, the term liability covered by the terms of the policy, it's defined in paragraph 6 of section 43. And I'm wondering if you could assist with the following. The definition reads that liability covered by the terms of the policy means a liability covered by the policy of insurance, or which would be covered, but for the fact that the insurer is entitled to avoid or cancel or has avoided or cancelled the policy. So, Counsel, I wondered if you could indicate how you understand the second part of the definition, meaning liability which would be covered, but for the fact that the insurer is entitled to avoid the policy.
Yes, Your Honor. And that can be answered in strict contract terms. The contract between the insurer and the insured allows for avoidance of liability if certain conditions are met. This was addressed by Justice of Appeal Phillips in the Jamaican case, Willis and Globe Insurance. And at paragraph 64 in that decision, she cited the board, the Privy Council in Motor and General Insurance Company against John Pavey, an appeal from the Trinidad and Tobago Court of Appeal. And she cited that the expression liability covered by a policy in section 10.1 in the Trinidad legislation means a liability which comes within or arises out of risk apparently insured by the express terms of the policy, whether or not it is a liability in respect of which the insurers are entitled to refuse an indemnity on the ground that the insured has committed some breach of the terms of the policy.
Counsel, in this particular case, let me be more specific. In this particular case, would you consider the exclusion on which your client is seeking to rely to be a fact that would entitle the insurer to avoid the policy? Or do you understand avoid here to have a different meaning?
No, it is the meaning you first suggested. It allows the insurer to avoid the liability to satisfy the judgment of the third party, because it is excluded by the policy, because the condition for exclusion has been met, whether it's driving without a driving license, or whether it is someone who never had a driver's license. Whatever the condition is, once it is met, it allows the insured to avoid liability.
Counsel, may I pick up on that point, that my interesting point that my sister raised? Does the policy itself tell us the circumstances in which the policy can be avoided or cancelled? And if so, what are those circumstances?
The exclusion here, Your Honor, is not one where the policy has to be avoided or the policy has to be cancelled. If the condition is met, the exclusion from liability is automatic. It requires no further action on the part of the insurer. So it is a situation that is dissimilar from one which gives the insurer the freedom to avoid or to cancel.
That may be so, but surely the cancellation or let's use a layman's word, disappearance of the policy will be contingent on how you define the term liability covered by the terms of the policy. Sure.
And then when you look to the policy, there's a schedule that deals with the exclusions.
Yes, there's that. But
once those conditions are met,
how do you reconcile that? I'm sorry, Counsel, with provisions of Section 43.3, which speak about avoidance of the policy in certain terms.
Non-disclosure.
In my respectful view, Section 43.3 does not apply in this instant appeal. 43.1 is relevant because a judgment has been obtained by a third party, and the third party is seeking to rely on the statutory liability of the insured to indemnify the first respondent. And it is the contract terms now, the exclusion clause in the contract, that allows or frees the insurer from any liability to third parties.
So, Mr. Thorne, can I just try and understand you? As I understand you, your point is this: not having a valid license under this contract of insurance was a basis upon which they could have voided the insurance contract. Hence, no liability under Section 43. Is that what your argument is?
My argument is because avoidance now will require an action on the part of the insurer, sorry. But here, no action is required because the provisions, the exclusion clause says if you are driving without a license, we have no liability.
So the fact of driving without a license is what exempts them from the liability, notwithstanding 43.1.
Notwithstanding 43.1.
All right.
Because
I have a couple questions which I'll just summarize and you can respond to them as you choose. You cite the decision of the Court of Appeal of Justice Blenman, and you cite the Willis Jamaica case, which does cite a Trinidad and Tobago Privy Council decision. My question to you is, Section 10.1 of the Trinidad and Tobago legislation is in pari materia. Would you agree?
Indeed.
Yes. Are there any Privy Council decisions that take an approach that aligns with what you call the strict liability approach of the majority of the Court of Appeal? I'm just framing it broadly for now, and in particular, decisions based on Section 10.1 of the Trinidad section.
Because from our research, we found none that takes this strict liability approach. On the contrary, the cadet decision out of St. Lucia, the
cadet decision is a Court of Appeal of St. Lucia.
Yes.
And I'm speaking about Privy Council decisions.
The board decisions in the two Trinidadian case referred to in cadet. Richardson Hill and Mohammed. Those cases
Do those cases say what you just said? Do those cases, do you look at the Matadine case also? Did you look at the Privy Council decision in Matadine from Trinidad?
I think, Your Honor, that was also referred to in Cadet, but I didn't read that.
You didn't look at the Privy Council decision itself, right?
But sorry.
No, do those decisions support this contention that if an insured is driving with an expired license, that allows the insurer to be exempted from liability vis-a-vis third parties, whether under Section 10 or Section 43 or its equivalent? Do any of the Privy Council decisions, in your opinion, support that?
Yes, Your Honor.
Which ones?
And those referred to by...
You mean referred to in the Court of Appeal decision?
Those that the Court of Appeal relied on, the two Trinidadian decisions in Richardson Hill and in Mohammed.
Okay.
And Mohammed and Risa were also relied on by the Court of Appeal in Jamaica in Meshack and Willis. And whether the condition is having an expired license or not having a license at all, once the condition is framed in the exclusion clauses, the courts enforce it and allow the insurer to avoid liability to indemnify the third party. And these cases, the Jamaican case and the Trinidadian cases, they all consider the unique situation in the UK, where there's a motor insurance bureau.
And there's none here. We have no compensation funds, but we have no equivalent. Yeah, I'm well aware of that.
And if we may very quickly, Your Honors, in the Jamaican case, Meshack Willis, compensation of victims of uninsured drivers. The injuries suffered by the appellant are serious and substantial, and it is most unfortunate that no facility exists in Jamaica to satisfy the judgment in this claim. The Privy Council and Presidential Insurance Company Limited and Mohammed and others, that's the Trinidadian case, Your Honors. The Privy Council has highlighted the steps taken by Great Britain legislature to protect innocent third parties from actions of uninsured drivers with the creation of the Motor Insurance Bureau. This agreement, the Motor Insurance Compensation of Victims of Uninsured Drivers Agreement, provides that if a judgment in respect of any relevant liability is obtained against any person in any court in Great Britain, whether or not that person is covered by a contract of insurance, and any judgment is not satisfied in full within 7 days, the Bureau will pay or cause to be paid the said sums in full with cost. While I recognize that unfortunately there is no institution of this type in Jamaica, the Jamaican legislature ought to take the crucial and novel step of being the first in the region to implement such a scheme in order to cure the social evil created when unlicensed drivers cause personal injury, property damage, or death to innocent third parties, for which there is no compensation. In Cadet, Justice of the Appeal Denman recognized the same lacuna and said it is for Parliament to fix. But the courts will have to apply the exclusion clause without passion or prejudice.
Counsel, would you assist me a bit here in terms of the exclusion clause? I see the exclusion clause says the driver does not hold or is disqualified from holding or obtaining a valid driver's license, or if the driver is entitled to indemnity under another policy. So if I may repeat,
Yes.
does not hold or is disqualified from holding or obtaining a valid driver's license. But Council, what strikes me in relation to that exclusion clause, drafted not by the legislation, but by the insurer, is that it contains language deliberately chosen, and it struck me as being in great contrast to the definition of license in the policy. So I'm looking at license, which is at page 293 of the record of appeal. I'm looking at page 4 of the policy. And it says license means a driving license or other permit issued by or on behalf of the licensing authority, which is, and here, permit me to emphasize, which is valid, and even more emphasis, and currently in force. So the policy considers two, as it were, qualifications or conditions which appertain to a license. It must be valid and currently in force. So it seems, unless it was tautology, that the policy considers that you can have a license which is valid and not currently in force. The exclusion speaks to valid, but does not require that it be currently in force. So there is excluded a person who is not the holder of a valid driver's license, but it does not exclude the holder of a valid and currently in force or not currently in force driver's license. So help me there. Validity, it seems to me, speaks to something other than the payment of the revenue fee and extending the valid driver's license for a further year. Help me, please.
And to do that, Your Honor, I must go back to Section 76, 2 and 3 of the Road Traffic Act, which references continuously the phrase expiry date with respect to a driving license.
Right. So we all know a driver's license expires, yeah?
Yes. And the definition of expire or expiry. The Oxford English Reference Dictionary defines expire as in relation to a period of time or validity. It means come to an end of a document, authorization, etc. It means cease to be valid or become void.
Sorry, the dictionary says cease to be valid?
Of a document, authorization, etc., cease to be valid.
Right. So that is right. So that is the definition of expire.
Yes, yes, Your Honor.
Yeah, but your policy seems to establish a distinction between validity, which the law connects with class of license not being disqualified, etc. So that is a valid license, not a valid license which is currently in force.
And
a valid license.
Sorry.
Yeah, go ahead.
No, sorry. My apologies, Your Honor.
Yeah, it seems to me that a valid license is one which appertains to a particular class, one which the court has not pronounced to be disqualified, suspended, etc., etc.
And Your Honor, please permit me to give one further definition, and then I will answer your question about valid and currently enforced. I will answer that bluntly.
Please, I'll be happy.
The definition of expire in the online Oxford Dictionary of English states of a document, authorization, or agreement. It means come to the end of the period of validity. And in the online dictionary, they always give an example. And the example here is his driving license expired. How ironic. And only this morning I was saying to my associates, the policy could have stopped that valid. So valid and currently enforced is tautologous. I think that is unavoidable, Your Honors.
The condemnation of it as being tautologous, yes, I can see why you need to so advocate, and I assure you, I will bear it firmly in mind that you have pronounced this to be a tautology on the part of the insurer's draftsman.
The Clause B license is a driving license or other permit issued by or on behalf of the licensing authority, which is valid. The full stop could have been there. I think to go on to say and currently enforced is tautologous, because if it is valid, that's it. If it is expired, it is not valid.
Like I say, Counsel, I totally understand you. It is a tautology. Your client's draftsperson was guilty of a very confusing exercise in poor drafting. Continue.
Thank you.
But you know, that raises the point, you know, Counsel. If you concede the poverty of the drafting point, are we entitled to invoke the concept of contra preferentum? I know it wasn't accepted in the Court of Appeal, but if the clause is right to uncertainty, aren't we in the realm of looking at the drafted clause and construing any uncertainty against that person? And before you answer that, there is, of course, the other point that are some cases at least that consider validity not in relation to the expiry of the license, but in relation to the authenticity of the license. I'm sure on the other side you'd have heard them refer to the Gilhary and Belize International Insurance Company case. We suggest that when we're speaking about the validity of the license, we're asking about whether the license was obtained improperly or by fraud or that kind of procedure. Mm-hmm. So validity need not, at least in the eyes of one court, relate to the question of expiry. And if that is the case, there is some ambiguity. And if there is ambiguity, I'm not sure that your reference to tautology necessarily applies. It could be that validity refers to this line of thinking. The license was obtained properly or not under the table, so to speak. And then also, the other requirement is that it must be enforced. Whereas, as my brother said, the exclusion clause refers only to the question of validity. What say you?
Firstly, Your Honor, with great respect, I would not equate tautology with ambiguity. Respectfully, sir. Sure. The clause having the formulation which is valid and currently enforced, I think repeating itself in different words does not lead to an ambiguity. It does not have any effect on the exclusion clause itself, which says the driver does not hold or is disqualified from holding or obtaining a valid driver's license.
It would be
Because-
tautologist if both the word and the phrase meant the same thing.
Valid, yes.
I'm sorry, Counsel. But if they do not, and if validity means one thing in the way I've sought to explain earlier, then that would be very different from the other phrase, in force, surely. So there would be, arguably, I would want to hear argument on it, there would be an ambiguity there.
That's what's in legislation.
And if it is, then the referendum rule might be applicable, wouldn't you say?
Millards, the legislation that was being considered in Gilhari is, I'd say, vastly different from our legislation, because the legislation referenced valid and has had or had a driver's license or has had and is not disqualified, and so on and so forth. Our legislation does not, the policy, that was the language in policy. Our policy here, nor our legislation, they do not have that or has had language formulation. And I think that is a distinction that must be borne in mind. The question of being obtained without fraud or other improper motive or process does not do harm to the policy here in the instant appeal. But that distinction, bearing in mind that we do not have the or has had formulation, then to that extent, Gilhari does not apply, and the line of cases dealing with that or has had formulation, they do not apply to the instant appeal.
Thank you.
Where am I know my time is running short.
I think your time has expired, not running short.
We started, my brother, just a little bit late, so
Thank you.
about 5 minutes or so.
I may have a minute or two available to me.
I think you have 5 minutes.
Well, thank you, Your Honor. So going on from my previous submissions, then the availability of the exclusion clause to the appellant, which is the third issue I wanted to address. The exclusion clause having been found to be fair, or as the Court of Appeal put it, it was not an unfair contract term, then it must be available to the appellant, like it was in Cadet, like it was in Willis, like it was in the Trinidadian cases. We all feel sympathy for the innocent third party, but as in those said cases, Willis, Cadet, Risha, Mohammed, it is for the legislature. It is for the legislature, and though our human nature is to make sure that third parties are protected and judgments are satisfied, we cannot impose that obligation on the insurer where the clear terms of the policy exclude them. To allow a driver to ex post facto renew his license and thereby put a liability on the insurer would be to expose insurers to liability to an indeterminate class in an indeterminate amount and for an indeterminate period.
Yes.
Insurers will never be able to calculate their
Counsel,
risk.
surely overstate.
I don't think so. With respect, I don't think so because
Counsel, it is not an indeterminate class, Counsel. In this instance, if, as in your footnote 14, the legislation were to have said that you cannot exclude liability because of the status of the driver's license, then it is simply that a determinate class, which is a whole of a valid driver's permit, who has not renewed it, is not excluded from cover. That's all. Come on.
No, all I'm saying, Your Honor, is that unless insurers are allowed to rely on their contractual escape, then there will be no way for the insurer to calculate his risk, because the insurer will never know who out there is driving without a driver's license.
I thought, Mr. Thornhill, if you would excuse me, I thought that was the whole purpose of the legislation, so that insurers cannot simply escape. I thought that is what Justice Valentine was explaining as he came to the end of his judgment around paragraph 45, that the whole purpose of the legislation, according to him, is to ensure that innocent third parties are compensated. And I thought you might have spent some time telling us about that, because that would be important.
By the way, counsel is a lovely Freudian word, escape.
Much obliged, Your Honor. Your Honor.
Sorry, in your response, because this would anticipate a question I was going to ask. In your response to my sister, would you mention as well that distinction between the physical risk and the legal risk, which I think is probably lurking somewhere in her question and perhaps in her answer? Thanks.
Your Honor, in the paragraph just cited, under where Justice Narang was considering the public policy behind, let's say, section 43.1, public policy considerations. Again, the learned Justice of Appeal was applying the strict liability approach to the section and justifying it by public policy considerations. Yes, the scheme of 43.1 is to protect third parties, innocent third parties. But where the terms of the contract provides for exclusion of that liability under certain conditions, then the courts apply the exclusion provided for, and the liability is the liability to indemnify ceases.
Even though the risk to the insurance company is not increased, certainly the physical risk is not increased.
No, I am not of that view. I've read the decision. I read the arguments. Yes. If a driver is driving without a driving license, then the insurer would be carrying a risk that he did not provide for. So whether the risk has changed or whether it has increased, if the driver does not have a license, then the insurer should not be on risk for any incident happening while the license is expired.
I think I understand you very much, Constance. Thank you very much. One very small last question, and I wonder whether there's a technological solution to this problem. and you may wish to consider it rather than answer it. Is it possible to have the expiry of the insurance policy being coterminous, coextensive with the expiry of the driver's license? And therefore, if somebody is driving beyond renewal date of their driver's license, the policy would have come to an end. That might involve all kinds of systems changes, and I don't know if that is or not. But I just put that down there as someone who's very results oriented as to whether that might be worthy consideration. That would not solve, of course, other clauses, which are exemption clauses, in the schedule. I fully accept that. But in relation to this specific issue, I just wondered whether I shouldn't just mention that. I would just leave it there because that's not part of the case. Is there anything else, very finally, one minute you want to say to us?
I think that is it. That is it, Milad. Sorry, Your Honor, that is it. Unless, of course, Your Honors have any specific questions to address the council.
Chair, I just wanted to ask Mr. Thornhill, why was 43(1)A added in 1983? What is the mischief that 43(1)A was trying to cure?
And I do believe 43(3) as well, Judge.
Yes.
Well, in 83, it seems so from what I see in the margin.
I tell you what, Mr. Thornhill, would you mind taking that under advisement and come back to us?
Yes.
When you
reply.
That might be very efficient. Okay, so can we then go on to the attorney for the first respondent, Ms. De Pisa, please.
Good morning, Your Honors.
Good morning.
I wish to start to deal first with the public policy issue and answer that query, because I do believe that that is the foundation for the entire legal framework within which the contractual arrangement will be made, and also the issue that is between the parties in this matter. The first respondent's position is that the legislation itself was designed to cover third parties more so than anyone else. And that public policy consideration is the underpinning of everything that we will be discussing here today. It also answers the question that was left hanging with the appellant just now, and that is, why were these additional sections added in 1983, all of which speak to the continued liability to a third party, notwithstanding default of an insured. It also speaks to the allowance of an out, if I may put it that way, but having to meet certain stipulations in order to get out of the contractual obligations. Because no matter what an insurance company puts in a policy, if it runs afoul of the legislation, then it is of no effect. So having that first as the underpinning and the bedrock, that there is a public policy to protect third parties on the road, then it gives an understanding of how far an insurance policy can go. And it also helps to explain why sections 1A through 6 were added in 1983, which give a roadmap for the escape if an insurance policy is to be avoided. And I say that because of the wording of the legislation. I disagree that Section 43(1) is written in terms of strict liability because it states first conditionalities. There must be a policy in place, at least on the face of it, before the third party can be triggered. But it also goes on to allow an insurance company, after having paid under the Act, to seek to reclaim from their insured. So there are ways and means around it which suggest that it is not strict liability. Having said that, though, the insurance policy itself and its exclusion clause, which was found to be unfair at first instance, but to not be unfair at the Court of Appeal, the position with the exclusion clause is that, like all exclusion clauses, it has to be strictly construed, and it has to be construed in the favor of the person who had no input into its construction. So the insurance company created a policy which allowed for a definition which was ambiguous. That is the position of the first respondent. And I put that in the context because then I want to spend some time, more time, on the provision of Section 76(3)(c), and to state the position that the license itself speaks to a qualification to drive and not to a skill to drive.
Yeah, Mr. Peter, before you go forward, because I still want to ask you something about the public policy considerations. Justice of Appeal Cumberbatch did not agree with his brothers. And he makes the point, and I found it interesting, that in his own words at paragraph 65, there is an equivalent public policy interest consideration in the freedom of entities, both individual and commercial, to regulate their affairs through contract. And I wanted to have your view on that, as you sort of saw how, first of all, how, if at all, we should balance that, consider that, and two, how does the legislation affect what Justice of Appeal Cumberbatch had to say?
Your Honor, I too found it interesting but not compelling because you cannot contract outside of the law. And the legislation is what states what the legal principles are in relation to motor insurance. The governing principle in terms of the protection of third parties is very carefully encapsulated in Section 43. That is to say, an insurance company first has to meet the legal considerations when drafting its policy. And if its policy, having been drafted, runs afoul of the legislation, then those sections have to be of no effect. It doesn't lean on unfairness. It leans on ineffectiveness in the face of the legislation.
Mr. Pizzo, what aspect of the insurance policy, because you've said several times that the policy can't run afoul of the statute. Are you suggesting that there's any aspect of the policy under consideration that did run afoul of the statute? And if so, what aspect of it?
The exclusion clause that is in issue before this panel runs afoul of the legislation in the estimation of the first respondent. This is because the legislation itself, first of all, gives directions on how to escape. It is not automatic as suggested by the appellant. The conditions set out, particularly at Section 43(3), that no sum is payable if a particular thing is done by the insurance company. That is, they have to take active steps in order to avoid. And then subsection 4, where even after getting such a declaration, there's again a procedure that has to be followed, suggests that there are steps which an insurance company must take in order to avoid. So it is not just simply having the exclusion clause within the contract, but that they have done certain things. And in any event, the exclusion clause, which speaks to a policy that is in force, there is no definition of what is in force that is allowable outside of what the legislation stipulates. And at section 73, section 76, I beg your pardon, section 763, it speaks to a renewable license, and it gives all of these stipulations under which a license will be renewable. Section 76, 6 goes a little bit further and speaks to when a test has to be redone. So it is not just about not renewing the license. There has to be more. So if your exclusion clause is written in ambiguous terms and your exclusion clause runs afoul of the legislation, then your exclusion clause is of no effect.
Mr. Pisa, let's explore a little bit more the notion that the exclusion clause runs afoul of the statute. Now, in section 43(1), because you have pointed us to, as you said, certain pathways to escape covered by paragraphs 3 and 4. But let's look at a situation where there is no action taken by the insurer to avoid the contract, avoid the policy, which is what paragraphs 3 and 4 relate to, more so paragraph 3, if they're alleging certain grounds to have the policy avoided. But there are words in parentheses in paragraph 1, which is that the liability must be covered by the terms of the policy. Section 48 deals with a number of conditions that are not allowed, right? I don't think it's being alleged in this particular case that there was any condition in the policy that falls within the scope of the terms in section 48 that can't be introduced into these types of policies. So I just wanted you to clarify a bit more what aspect of this exclusion clause then runs afoul of section 43 in particular. In other words, is there some inconsistency in your mind between what the policy purported to exclude and any requirements under the Act? Thank you.
Yes. Now, the policy purports to exclude insured persons whose licenses have expired. When section 76 refers to them as renewable licenses. So it goes further than expiry and speaks to them being renewable. So the license is expired, but it is renewable because it is not, and using the terminology of the legislation, it is not previously suspended, it is not previously canceled, it is not previously revoked. That is section 76(1). So to introduce another category which is not contemplated by the legislation for those which are inadvertently not renewed. And I use that language because that is the language of Gilhari, where it is through inadvertence. Then The argument on behalf of the first respondent is that the insurance company does not have the leverage to go that extra step and speak to policies which are simply not renewed because they are renewable under the legislation, Section 76.
So your argument, Mr. Pisa, is restricted to this particular exclusion clause.
Yes, it is.
Because the schedule has about 9 exclusion clauses.
There's only one in contention before us, sir.
I'm aware of that.
So it's just that one that I'm speaking to.
Sure. But what I'm asking you is, because obviously we have to look at everything and the implications of what we decide here. Are you saying that in each case that comes up before this court involving any of the 9, we would have to go through that process that you just took us through to see whether, again, any of the 9 is compatible with the let-offs provided for in the statute? I'm just trying to get a feel as to what your approach to this would be.
That would be my approach, because in each case, you first have to have the statutory basis before you can step towards the contractual arrangement between the parties, because the parties can agree to anything so long as the legislation allows it.
So in a sense, you are implying a word into 43.1, which now reads, relevantly, being a liability covered by the terms of the policy. Are you saying being a liability validly or properly covered by the terms of the policy? Are you seeking to read words into the legislative language there?
Respectfully, sir, no. Because the first part of the section, not in parentheses, deals with a certificate of insurance that has been issued. So the issuance of the insurance is not a difficulty. It is whether, and the liability covered by the policy is also not the issue, but it would be whether or not, having regard to the entirety of the legislation, if the provisions of that certificate of insurance effectively run afoul of the legislation.
I see. Thank you.
Thank you. Now, in relation to what I consider to be the largest issue in the matter, and that is in relation to Section 76 and whether or not the policy, the license being renewable, is in effect putting the holder of the license in the position as if he had paid from the very beginning, which is a point of diversion between the parties from the inception. It is the position of the first respondent first to speak to the use of the term retrospective by the Court of Appeal, which in my humble view is simply a misappreciation, and they are two interchangeable terms. One is retrospective and one is retroactive. They have subtle differences. The arguments being made, though, are in relation to the retroactive category, and that Section 76(3)(c), in the manner in which it is worded, allows for the reinstatement of a license that has lapsed. It states that if on a date prior to that on which the license is presented for renewal, the license is renewed and the holder, it is expired, When he comes to pay, he is required to pay a fee calculated on the period commencing from the expiry date. So to use the example given by Your Honor, if it expired on the 1st of June and the insured turned up on the 1st of September, then that license fee has been paid and covered from the 1st of June through to the 1st of September and on to the next expiry date, whether it is renewed for 1 year, 3 years, or 5 years as allowed by the law. What that does then for an accident that occurred in August is that on the face of the license, the license is in effect for that date. And this retroactive operation of Section 76(3)(c) makes sense when viewed in terms of that overarching public policy consideration of Parliament, because the intention is to protect third parties. Whether that has any impact on the insured himself as to whether under Section 61 he is open to any action by the state has nothing to do with whether or not the third party remains covered under the legislation. Because the intention of the legislation is to protect third parties, not to protect the insured, but to protect third parties. So in allowing the license to be reconfigured, dating back to, using the example, June the 1st, it permits a third party who suffered injury in August to be covered by that policy of insurance because it is no longer an issue for the third party, whether or not it remains an issue for the insured.
Let us say the insurance company, sorry, counsel, gets wind of the fact that there was this accident before the insured pays the renewal fee. What then?
I beg your pardon, sir?
Let us say, for the sake of argument, that the insurance company is made aware that there was this accident, and that awareness came before the date on which the insured renewed his driver's license. What then?
Then, sir, the provisions of Section 43, the subsections of Section 43, would be available to them if they wish to avoid or cancel the policy. There are options. They can either avoid or cancel the policy.
So in the circumstances I just hypothesized, you would agree that there is no protection to the innocent third party, provided, of course, as you say, the insurance company follows the procedures indicated.
If they follow the procedure. And not following the procedure is a feature of this case as well. It was raised at first instance, okay, but not following the procedure is to be taken into.
I understand you. Not to interrupt you. I'm sorry to do that, but I'm just trying to get clear. Your overarching argument about the protection of the third party, and I think we all agree that that is certainly appears to be an objective of the RTA, does not apply, apparently, and you're conceding it doesn't apply in the case I just mentioned.
Well, unless, of course, the Gil-Harry decision, which states that inadvertence should not disallow a claim by a third party, will save it, but that is outside of the legislation and simply by applying the precedents that are available.
Yes, so that would be a different line of argument, wouldn't you agree?
Yes, yes, it would be.
Yes.
But Mr. Peter, can I ask a question? I was trying to get this from Mr. Thornhill, and maybe he will come back and clarify it in his reply. These 1983 amendments, the what you call the use an expression, it's sort of the opt-out, or I forgot what expression you use now, allowing an out to the insurance companies. Is it correct that that whole scheme, well, the mischief that was happening is that the third party sues the driver owner of the vehicle, and driver owners can make themselves judgment proof. And so it's virtually impossible to recover the compensation. And resort to the insurance companies under third-party liability, well, that was supposed to be okay. But if the insurance companies wait until 5, 10, 15 years after to exercise this avoidance, then at an early stage, the third party does not have an opportunity to intervene against, for example, insured, to prevent them from making themselves judgment proof by all the different remedies that are available. And so is it correct that one of the things that informed the insurers doing this and notifying the third parties about this process of avoidance was, in a way, statutorily to allow third parties at the get-go, because they have a short time period within which to do it, right? From the get-go, to be aware that this can happen and to take steps available to, where possible, try and prevent the insureds from making themselves judgment proof. My own experience in Trinidad is that was a real phenomenon. And these things come at a certain, if you trace the history. So I don't know what it was like in Barbados, but I would be curious to see, these things happen at a certain time. And why were they happening at that time? And what was the rationale and explanation given by the proposer for this happening? So does that line up? What's your insight or understanding about that?
I confess I have no insight into it at all. The timing of the insertions was not a part of my research. I do understand the point that you're making, though, and it does arise in this circumstance where the insurance company sought to trigger any activity 3.5 years after the incident. So I appreciate the position that you take. That
I'm asking you a question as to the rationale in Barbados. I don't know knowledge of why it happened in Trinidad, for example, but I'm trying to add. That's why I asked Mr. Thornhill about the rationale or the mischief being addressed in 1983, 30 of 83, when this whole regime was put in place, right? A process to avoid. And the question, it begs the question, if you do not adopt the process to avoid, what is the effect on 43.1? When you read all of 43 as a whole, if 43 has been amended, that 43.1 has been amended to create a process to avoid. Mr. Thornhill agrees to us that this is a case where that could have been triggered. He says it is an automatic trigger. The legislation seems to provide a process for it. Well, now that amendment has happened, and if you have to read Section 43 as a whole with the amendments, to my mind, it raises a question: what is the effect in law if you do not follow what the statute prescribes? Which is, I suppose I'm asking you exactly what I asked him, which I think he'll come back to and give his views on later.
My view, though, in respect of that final question, I can't speak to the rationale as to, and in relation to the timing, but certainly to my view, the effect is if the statute gives a procedure and you do not follow it, then you cannot rely on it in order to either avoid or cancel the policy.
Okay. Any further points, Mr. Pisa?
In relation to the section 76.3, I just wish to reiterate that the failure to pay the license does not speak to competence at all. Therefore, it is not a factor in assessing risk. And risk from the inception of this action has been an argument by the appellants as to why they ought to be allowed to avoid, that their risk was increased, and that is why they ought to be allowed to avoid. I go further. If it were that the insurance company appellants held the view that it was automatic, there would be no need for this litigation. It cannot be automatic. It must be that there is a process, they follow the process, they have not done so, and this is why we are here. They sought a declaration, but they sought it 3.5 years after the fact, and cannot now claim that cloak, and that, to use their word, escape.
How do you respond to the argument that the risk did increase because they were, in their view, on risk up until the point when the license expired? Thereafter, your client, the insured, ought not to be driving on the roads. So if he's not driving on the roads, then clearly there is a significant, perhaps absolute, reduction in the risk that they carry. How do you respond to that?
The initial response to that is that the risk does not increase. His skill is not diminished because he does not have his license paid up. And the license is indicative of your skill, your qualification to drive.
With respect, I'm not sure we're on the same page. What I'm saying is that an argument which could be made, and in fact may well have been made, is that the risk necessarily increases. In fact, put another way, there is no risk to the insurance company once the expiry period has arrived. The only risk that they undertake from then on is one where somebody who ought not to be on the road is in fact on the road. And if he abided by the terms of the policy, which he agreed with the insurance company on, then they would have no risk because he would not be driving without a valid license in force on the road.
So permit me to answer it in the reverse.
Yes.
And that is, in negotiating the policy with the insurance company, the insured has to produce certain documents, including his license. The first respondent produced his license, which very clearly on its face would state its expiry date. And yet still the insurance company granted a policy of insurance beyond the date of expiry of his license. They can be said to have assumed the risk and therefore should not be allowed to avoid it once the circumstance has arisen.
I follow you. What about the point I raised, and again, it might not be for us lawyers, of the technological solution of having the two things being coextensive?
Coterminous, yes. I agree that that is a solution. It is, however, beyond our powers today to effect that solution, but It is an obvious one that an insurance company ought not to issue an insurance policy for longer than the risk they intend to hold.
Except, Mr. Pisa, when the insurance company issues a policy, it is issuing a policy in accordance with law to cover the user of a particular vehicle. So they are insuring not just the person who pays for the policy, but they are insuring as well the user of that vehicle. And as we all know, that user may be done by the wife of the insured, the children of the insured, the employed driver of the insured, a good friend, etc., any authorized driver. Therefore, the user of the vehicle, I think, is in fact what is in issue here. And if an uninsured, or sorry, if an owner whose policy has expired does not drive during the period when his policy is expired, he simply does not renew and he does not drive. That does not stop the vehicle from being driven. It does not stop the insurance company from having the obligation to cover. And therefore, in terms of a reduction of the risk, it simply means that one person out of the many who could drive the vehicle would not be driving the vehicle. So I really don't see that there is much that can be done. Thank you.
Thank you.
Mr. Pease, I just want to be clear on something. It seems as if your argument is that beyond, well, let me ask the question. Let me make sure I outline my thoughts properly. Section 48, as I understand it, limits certain restrictions that an insurer can place on policies covering third-party risks. Paragraph 1 sets out a range of matters that cannot be used to in any way limit the scope of liability that can be covered by a policy covering third-party risks. What I'm trying to be clear on is, are you suggesting that a policy that utilizes a factor for excluding coverage or limiting the scope of coverage outside of these considerations, right, could still run afoul of the statute? So there are, from subparagraphs 1A to I, there is a listing of a number of matters or factors which the statute prohibits as being used for the purposes of restricting the scope of a third-party motor vehicle insurance policy. We are dealing with a policy that used factors other, well, let's stick to the one that we're dealing with here. The factor in question that governed exclusion is not covered by any of these. I'm still trying to understand the basis upon which the first respondent is arguing that the exclusion clause ran afoul of the statute. That's a separate argument from the situation we're dealing with was not covered by the exclusion clause. In other words, one line of argumentation is focused on the interpretation of the clause in the policy. But your argument seems to be that the clause itself runs afoul with the statute. And I'm still not fully understanding why, if we're not dealing with any of the restrictions that are covered by section 48.1.
The reason is that I have a different view of what Section 48 covers, because Section 48, to my mind, does not impinge on the rights of third parties. It impinges on the rights of the insured. It says where a certificate of insurance has been issued under the appropriate section in favor of the person by whom a policy has been effected, so much of the policy as purports to restrict the insurance of the persons insured, thereby by reference to any of the following, is void. So this is in relation to the person insured as opposed to third parties in the estimation of the first respondent. It doesn't apply to liability to third parties, but the liability to the insured.
But it says is void as respects the liabilities required to be covered by a policy under Section 38(1).
Yes, it does, but the two relate to each other, and the first part cannot be excluded by the second part because, pardon me, let me just get Section 38(1) in hand.
Okay.
Right. Section 38(1) ensures not only third parties, I beg your pardon, it's a policy of insurance issued by a vehicle insurer to insure persons or categories of persons specified in the policy against liabilities to certain amounts arising out of a motor vehicle on a public road. So there are two categories. One is the liability to the insured, and the second is the liability to third parties. It is very possible to exclude the liability to your own insured but remain liable to third parties.
So you don't read section 48(1) as speaking to the impermissible restrictions on the scope of third-party insurance policies?
I don't see it as limiting third-party insurance.
Interesting.
Okay, I think I have a different view, but okay. Thank you.
Yes. I was wondering, Mr. Pisa, whether you would have alighted on E, 48(1)E. I didn't realize you were going in the direction that you went in. But
I beg your pardon, my legislation is now all out of order because I separated it. Section 31E?
No. 48.
48E.
1E. In response to my sister, I thought that's where you might have landed. But
the times at which, or the area within which the vehicle is used?
No.
Relation
person's name in the policy who may or may not drive a vehicle.
Oh, I'm
sorry.
Yes.
But obviously,
that too could offer some coverage.
I'm sorry?
I'm only now considering it, which is why I took a moment, because the exclusion clause does limit who may drive the vehicle. Yes, there may be some leverage there, but I must confess that did not feature in my argument.
Yes. Thank you. How much longer do you wish to go for, may I ask? Or are you?
Well, I was told that I had half an hour. I believe I have exhausted it, sir, and then some.
And then some.
And then some. Yes, sir. So only now, sir, to segue slightly and congratulate you on your elevation.
Thank you. That's very kind of you. I assure you that will play no part in our decision making.
None whatsoever, sir.
Okay, thanks again. All right,
Yes.
colleagues, shall we press on or take a little break? Justice Rajnath-Lee, which would you prefer?
Thank you, Chair. I have no particular preference. I can press on if my colleagues wish.
We will press on.
President, I can give you every assurance that Sir Richard will be the essence of brevity.
And I always accept your assurances, my brother. Thank you so much. Counsel for the second respondent, please.
Good morning, Your Honors. Sir Richard has asked me to lead the argument this morning on behalf of the second respondent, and I can assure Your Honors that I will be as brief as my senior would be in the circumstances.
You have been taught very well, no doubt. Thank you.
Your Honors, I wish to remind everyone of the context of this case, and that is that an unsuspecting and innocent woman was walking along the road when she was struck by the first defendant's vehicle and she died on the scene. We are now 17 years on, unfortunately, with this matter, and her family has not been compensated for her passing, notwithstanding the fact that the driver was the holder of a valid policy of insurance, which was enforced at the time of the accident. And it is precisely this sort of circumstance that the Barbados Parliament had in mind when it enacted the relevant provisions of the Road Traffic Act. And I think I would wish to start by going back then to where my learned friend left off in terms of Section 43 of the legislation, which makes provision for the payment of a judgment to third parties, even in circumstances where an insurer would otherwise be entitled to avoid or cancel a policy unless that insurer had taken the precautionary step of having cancelled the policy prior to the issuance of a judgment. We should also, Your Honors, bear in mind that the liability in this particular case, that is the death of a third party, is precisely the liability that was contemplated by Section 43(1) and which was provided for under the policy of insurance. And respectfully, we cannot agree with my learned friend for the appellant, suggesting that this was the imposition of a strict liability on the insurance company. The insurance company has assumed the risk in these circumstances when it issued a certificate of insurance, which was not strictly coterminous with the period of the license in question. The insurance company was also aware that it was being asked to assume this type of liability in circumstances in which the expiration of a driver's license under the legislation does not materially or at all impact on the risk that has been assumed by the insurance company. And I would wish, Your Honors, to highlight certain issues in the legislation as well, because to return to the issue of whether the exemption clause is an illegal contract term, our position would differ slightly from that of the first respondent.
Mr. Turan, sorry to interrupt you.
Yes, Your Honor.
This policy also covered other users, yes?
Yes.
So if on the day in question 17 years ago, an authorized user was using the vehicle and this accident had happened, would the insurance company have been able to avoid the policy or attempt to avoid the policy on the basis it is in this case?
I would argue no, Your Honor, and that is because the user would derive his coverage from the insured person, and our position is that the insured in this case was at all times covered by the policy.
So the alleged invalidity of the insured does not, in your opinion, that did not invalidate the policy in toto vis-a-vis, for example, legitimate users of the vehicle.
No,
The scenario was what Justice Barrow raised. If, for example, the insured had the same scenario happens, and the insured's license expires and is not renewed, but another person duly authorized took up the vehicle and drove it, and and this accident happened. Could the insurance company say that, look, the policy can be avoided on the same basis, even though the person who was driving the vehicle was an authorized user against whom there is no, in other words, not a person who does not have a valid license?
That is an interesting question, my lord, but our position is that at all times in this case, the insured was properly covered by reason of his license, because he had the ability, and this is perhaps where I wish to draw attention to certain provisions of the Road Traffic Act. And we must also bear in mind that the question of the risk that is being assumed by the insurance company is a material consideration in interpreting the policy in this case. So, for instance, under Section 76(7) of the Road Traffic Act of Barbados, a driver who is over the age of 70 years may not be granted a license for a period of more than 1 year. Under Section 76(8), where a driver has not renewed his license for a period of 3 years, he may be required to retake a licensing test. And additionally, there are a number of provisions which set out criminal offenses for which a driver may be convicted and then disqualified by law. And these particular exceptions all speak to the physical fitness of the driver to drive, his competence to drive. And in each case, then, we can certainly accept that that driver poses a risk to persons on the road, and his fitness in those circumstances impacts on the risk that has been assumed by the insurance company.
But you don't deny that the insurance company is within its right, whatever the fitness, and whether this is a NASCAR driver, to fix a period during which it is on risk.
That would be within the rights of the insurer, Your Honor.
Okay.
To limit their liability, yes.
Yes. And could it not fix that period by reference to factors such as the expiry of a driver's license?
They could, my lord, to take your example earlier, and to certainly make it clear then, I could see a situation where a policy is written to limit the liability up to the period of the expiration, and then add a requirement that it can only be renewed once the driver has presented his renewed driver's license. And in fact, my understanding is that some insurance companies actually require you to bring back in that license and to demonstrate that you have in fact renewed.
Exactly. And if that doesn't happen, then the policy is at an end, I assume. And nobody else can drive, whether it's an employee or spouse or neighbor or whomever.
Yes.
However driving they may be, the policy doesn't exist. So
yes.
I'd love for us to think, and I use the word us in a broad sense, of a solution which would not have us come back here on this kind of issue. We need to find solutions that work. I do think that is one that is worthy of consideration, albeit I accept that it is not directly before us. Thank you.
Yes, Your Honor. And I would only add then that in such circumstances, the exemption clause would have to be very clearly written, because
Yes.
there are insurance companies that continue to extend coverage beyond the expiration of a license, because that is precisely what happened in Gilharry. That is exactly what Chief Justice Cotran had in mind, where he said, you know, validity has certain meanings, or it can have more than one meaning, which seemed to be the ratio of his case. And in that instance, the exemption clause was extended, and it covered a person who had had a driver's license. But respectfully, the dictum of Chief Justice Cotran is very relevant to the resolution of this matter and to the determination of the question of the validity of the license. What we have in Barbados is a scheme which allows for the automatic renewal of licenses on the payment of a prescribed fee. In this particular case, the first respondent never came outside of that automatic renewal. He was at all times entitled to that automatic renewal, and he was able to renew even after this accident took place. And the administrative fee, the payment of this administrative fee, was back calculated to cover the period where he had not paid. But our position, respectfully, is that he was not deprived of the benefit of the policy of insurance, nor was the third party, because his license had been properly obtained, applying the definition that Chief Justice Cotran has used. That is, that it has been not obtained by reason of some fraud or misrepresentation. And there is respectfully quite a lot of good sense in what Chief Justice Cotran has said, because it gives effect to the legislative intent behind the Road Traffic Act, which is to protect the public. And in fact, he was quite emphatic in saying that the simple non-payment of a fee, if it was the case that the third party's rights could be defeated or extinguished by a mere failure to renew a permit on someone's birthday, that would be to defeat the purpose of this legislation.
Counsel, I wanted to follow up on a point here. In the submissions of this second respondent at paragraph 24,
Yes.
It's clearly your position that the question of whether a license is valid can only be determined with reference to the Road Traffic Act. So in other words, your argument is that we can't understand what a valid license is without reference to the statutory framework.
Precisely.
So are we then to take it to mean that for the purposes of understanding what liability, I'm now trying to pivot a little bit to section 43.
Mm-hmm.
For the purposes of understanding what liability is covered by the policy,
Mm-hmm.
are you arguing then that in interpreting the exclusion clause, the court should assess what a valid license is, not by reference to the definitions of terms in the contract, in the policy, but with reference to what a valid license means in the statute? There's a big difference. I'm also asking that question because the term valid license appears multiple times in the Road Traffic Act.
Mm-hmm.
And I'm wondering if you think there's a single understanding of the term valid license, or if the term valid license has to mean something different in the context of the third-party insurance framework of the statute. So those are two questions I have. Thank you so much.
I'm grateful, Your Honor, for that question, because it can be, the second question can certainly be answered by reference to the concept of a mobile term in a piece of legislation, so that the question of validity may have to be interpreted in the context of the specific section under consideration. For instance, when we look at section 61 of the Road Traffic Act, it does not make reference to a valid license at all. It simply says that if you do not hold a license for the class of vehicle that you are driving, you are guilty of an offense. And that may simply mean in that context that a person is driving who has never had a license. That's all it may mean in that context. In terms of Section 43, however, there is certainly no reference to a disability on the part of the insured, whether under the contract or a statutory disability, as a grounds for avoiding or canceling a policy. In fact, the converse is true. The statute is saying that the insurance company who has issued this certificate of insurance has undertaken within the terms of the Road Traffic Act to honor a judgment properly obtained. Its remedy then is against its own insured for any breach of its contract terms. And in fact, what is interesting is that Section 43.3 sets out a ground of avoidance, and it sets the bar rather high. It talks about a material non-disclosure, which allows an insurance company to simply cancel the policy. You never had a valid policy in the first instance because you have made a material misrepresentation of some kind. But to follow on to what my learned friend for the first respondent said, this is certainly not a situation of that kind, because the insurance company was always aware that the period of the policy went beyond the expiration of the license. And it was certainly open to the insurance company, as my learned Honor Anderson has raised here, to clearly delimit it, which it has respectfully not done in the circumstances of this case.
Counsel, just one other question, because it followed on from something that you just said. There's a particular interpretation of Section 43, which the second respondent has adopted. And here I'm looking at paragraph 43 of the written submissions of the second respondent. You've argued that even if the court were to conclude that the appellant was entitled to avoid liability under the terms of the policy of insurance, you are saying that that would not remove the appellant's statutory obligation to satisfy the judgment. And it comes back to a question that I had asked earlier of the appellant as to the reading of the definition of liability covered by the policy in Section 43.6, because you have argued quite clearly that even if the insurer has some basis for avoiding the policy, the insurer is still required to satisfy the judgment. And that's why I'm asking now, what is the understanding of the basis upon which an insurer could avoid the policy? Is avoiding the policy narrowly to be understood as the grounds that are referenced in paragraph 3 of Section 43, meaning there's been some material non-disclosure, there's been some kind of misrepresentation, or is the understanding of avoiding the policy wider than that? Because if I'm understanding your argument correctly, it could lead to a conclusion where even if there is, on the terms of the policy, a basis for liability being excluded, there would still be a responsibility on the part of the insurer to satisfy the judgment. Thank you, counsel.
Yes, ma'am. And let me preface my answer by reminding us all that under the Road Traffic Act, there is a requirement when you institute proceedings to serve a notice on the insurance company. And that is, one would imagine, precisely so that the insurance company can assess its liability in this case, it can take certain steps then to either assume responsibility for the defense of the action, which many insurance companies do, or alternatively, it can relook its policy and decide then that they want to take the statutory step of then canceling the policy so that the claimant as well is aware of the insurance company's position. And respectfully, that simply is consistent with good regulation of the insurance industry generally, because parties should know where they stand relatively soon. And I think that is why the legislation has said that you must take these steps within 3 months. We should be able to know where we are going. And I would argue, ma'am, that avoidance in this context does not mean anything more than what is provided in the legislation. So that I would take a narrow approach to the question of avoidance and say that it does not mean anything other than what the Barbados Parliament has already provided as a grounds for avoidance in the legislation.
Okay. Anything further?
So, Mr. Chair, I just want to round up that point from my understanding. So, on the statutory interpretation point of Section 43, your position is Section 43(1) cannot be read in isolation. It must be read in its entirety and, of course, in the context of the larger Act. And when you read it in the context that is within the sections, including the amended sections of Section 43, we have to read 43(1) through that lens. In other words, when 43(1) speaks about avoid or cancel or liability required to be covered, first thing we need to do is make sense of all of that within the broader context of all of 43, which includes sections like 43, 1E, and 3, etc. And that, you say, leads to a narrow interpretation. But may I ask you whether you would be willing to consider reframing narrow and frame it through the policy of the section, which is, it is to be interpreted in alignment with the intention of Parliament to protect third parties.
Yes.
As opposed to saying narrow.
Yes.
Because I think it makes a difference to say narrow or wide, as opposed to saying through the lens of the intention of this in relation to 43, as the marginal note says, the duty of insurers to satisfy judgments against persons insured in respect of third-party risks. Of course, marginal notes are not an aid to interpretation, we know that. So I'm just using that as a shorthand to summarize the method of statutory interpretation in relation to 43. Would you agree with that?
I would agree.
Or as you usually say, my brother, with a purposive interpretation.
Absolutely, thank you. I of course always stand corrected by my seniors, and so please take the supposition as reframed by Justice Barrow, Ms. Sitcharan.
Yes.
Ms. Sitcharan, yes, it is not a correction at all. It is a celebration of the jurisprudence for which my brother is responsible.
Yes. I'm grateful to you, sirs. In fact, I believe in our submissions, we referred to consequential analysis as part of the court's obligation in interpreting all of these sections. And I think that to come back to His Honor Jamadar's question about Section 43.3, it is in fact this sort of reason that the test in Section 43.3 is so high, because as a contract of the utmost good faith, it is important that insureds comply with this type of obligation, which can materially impact the issuance of the policy, the premium, the calculation of premiums, and that sort of thing. But
just to build a little bit, as Chair Justice Anderson raised a little earlier, therefore, to the extent that there may be any uncertainty or ambiguity or competing interpretations, the contra preferendum rule should apply, filtered through the purposive lens that
I would just wish to. It's unfortunate that it is not part of our research either. Why these particular steps were taken in 1983, except to say that my learned senior has reminded me, and in all of our jurisdictions, you could have issues with different financial institutions, including insurance companies, with respect to their standing and their liquidity. And that is too why Section 44 goes on to deal with bankruptcy. So if you have a subsisting claim, the supervisor of insurance, now the Financial Services Commission, can address those matters.
Okay. Thank you, Ms. Sitaran. Is that it? Can we pause there?
Yes.
Yeah.
Yes, Your Honor.
Wonderful. Well, thank you again. I'm sure you will join with us in thanking Sir Richard for his work in enabling you to make the kind of presentation that you did. Thank you so much. Mr. Thornhill, would you care for a reply, sir?
A brief reply, Your Honors.
Yes, thank you.
Mr. Thornhill, judges are so very familiar with when lawyers say brief.
I intend to honor my word, sir. Counsel for the first respondent refers to the exclusion clause as not being automatic. It requires the insurer to trigger the avoidance of the policy. And learned counsel for the second defendant also spoke in terms of avoidance. But I again wish to highlight that the effect of the exclusion clause is to create the situation where the liability or the claim was not covered by the policy, where the condition is met. For example, driving without a license, driving with an expired license. If that situation is satisfied, then it is considered that the liability is not covered by the terms of the policy. And I refer Your Honors to, again, Michak Willis and Globe Insurance Company of Jamaica, decision of Justice of Appeal Phillips at paragraph 80. Quickly read, Justice of Appeal Dukuran stated in Advantage General Insurance and Lord Heeman that the defense that a motor vehicle was being operated by an unauthorized driver at the material time is a clear defense. This view was also accepted by the Privy Council and Presidential Insurance Company Limited and Mohammed and others, where Lord Hodge, at paragraph 16, speaking on behalf of the board, the Privy Council, stated that when interpreting the section, the words in parentheses, being a liability covered by the terms of the policy, does not prevent an insurance company from pleading successfully the defense that the claim was not covered by the terms of the insurance policy. In light of the express provision in the insurance policy, in the instant case, that permit only the flames and persons authorized by the flames to drive, provided that they are permitted to drive by Jamaican law, in my view, Justice Mangatal was correct in finding that the liability that arose as a result of the accident was not a risk that was contemplated or expressly provided for by the respondent. Consequently, there's no requirement for the respondent to indemnify the appellant. The appellant here has consistently pleaded that the liability was not one that was covered by the policy because of the exclusion clause. So once this honorable court finds that the driver, the first defendant, was driving at a time when he did not have a valid license, then that defense of the appellant must succeed. Your Honors, to address the question posed to me by Her Honor, Madam Justice Raghunath Lee, as to sections 43(1)(a) and 3, I, like my learned friends, for the respondents, cannot speak of the climate that existed back then, or what would have informed Parliament to enact these additional sections that would require further research, Your Honors. Section 1A allows a third party to recover where the liability covered by the policy is not required to be covered under the Road Traffic Act. Now, remember that the policy is between the insurer and the insured, and this section that is recognized and accepted by all is for the protection of third parties. So it allows the third party to benefit from the contract between the insurer and the insured, and where the policy covers the liability as between those parties that is not required to be covered by the legislation, the third party may benefit from that contract. But with respect, my lads, that doesn't, with respect, Your Honors, that doesn't arise in this instant appeal. With the greatest of respect, sirs.
Mr. Thornhill, before you move on, can I just ask you, I had put something, I think, to Ms. Sicharan, and I just want to put it to you to see if you will agree that, you know, one of our tasks is the task of statutory interpretation to, in particular, read and interpret and apply Section 43(1). Do you agree that we must read and interpret and apply Section 43 by reading it in its full context and purposively through the lens of protecting third parties? And secondly, if there is any uncertainty, ambiguity, or plausible competing arguments exist, then contra preferendum interpret it so as to protect third parties. Would you agree with that as a methodological approach?
Your Honor, were I to disagree with that, maybe I should surrender my license to practice law.
Well, I take that as a compliment with appreciation, but I note your agreement. One last bit, maybe I can just add on to that. When we read the Privy Council decisions in this area, should we bear in mind two things? One, the deference of the Privy Council to parliamentary supremacy, and two, should we bear in mind that Barbados is a constitution, or the constitution is supreme, and as this court has developed, the for example, the protection of the law ought to be considered when we apply it within the Constitution, but also to the interpretation and application of all law, in this case, Section 43. And so in the process of interpretation, we need to also consider this idea of the protection of the law, and in this case, that would be in particular of third-party rights, given that is the dominant context of Section 43. How would you respond to that?
Your Honor, that
I think you should be hesitant before you offer to surrender your license on that
one. Thank you, Your Honor. But I was only going to say that that approach must also be taken when construing the entirety of the Road Traffic Act, including, in particular, Section 76(3)(c).
Yeah, okay, yeah, thank you. Yes, I agree.
Okay.
And the second point addressed to me by Madam Justice Raghunath Lee was Section 43(3). And this allows this section allows an insurer to avoid his liability to indemnify on the ground of non-disclosure of a material fact or by a representation of fact that was false. And in this situation, there's a time limit within which to make an application to court for such a declaration. Again, with the greatest of respect, Your Honors, not applicable in this instant appeal. And that, just one last point. Section 48(1) was raised by, I believe it was His Honor, Mr. Justice Dennis Barrow. But regardless of the source, this section was considered in cadet. The section there under the MVIA is section 11. And their view of this section, which is our section 48(1), is that it renders inoperative a specifically prescribed and exhaustive list of restrictions on the scope of a policy of insurance covering third parties. And those provisions, if found in a policy, are void, particularly as respects third parties. But I don't think that situation arises for consideration in this instant appeal. And that, Your Honors, is counsel's reply to my learned friends for the respondents. And I trust I've done it within time. Honorable Mr. Justice Dennis Barrow.
I think he's quite happy. He's smiling. So I think the answer is probably yes. Thank you very much.
Much obliged.
Okay. I assume, Ms. DePisa, that you are comfortable. You don't need to add anything further.
I am quite comfortable, sir.
Thank you very much. And Ms. Cicharan, that's same for you?
Yes. The same for me, except, sir, I think my Leonard Senior just wanted to say something briefly to you.
Just before we adjourn, sir, you will permit me to congratulate Justice Anderson, who will, as I understand it, assume leadership of the court as of July. I want to extend to him my warmest congratulations. Thank you.
Yes. Thank you, Sir Richard. Gratefully received.
And Your Honor,
yes.
please permit me to adopt the congratulations expressed by, in the first place, my learned friend, Mr. Pisa, and secondly, by my learned friend, Sir Richard. I adopt them as if they were my own.
Thank you very much. Thank you. Much obliged. So, colleagues, thank you very much for your argument. Very interesting case, evidently. We will reserve judgment, take some time to consider, and once we have arrived at a decision, we will alert you as to when that decision will be available.
Chair,
thank you.
Before you end, I'm sorry there's a thought in my mind, and I'm just going to raise it and leave you to manage it if you think it worthy. Some of the conversation has turned on, the meaning of 43 and the policy. And I don't know whether you consider there's a value in all parties being given an opportunity to do the research that I gather none of them have done, and to look into the context. What did the proponent of the legislation say when they said this? Because we are trying to discuss, this is a matter that, of course, impacts many people, insurance companies, third parties, etc. And is there a value to all of us and to the development of our jurisprudence, however it goes, to have the benefit of what the Parliament thought? Because I noticed this is a consolidation act, actually. And that doesn't surprise me, because in Trinidad, for example, the act existed since 1966. So there were antecedents to this, but it seems it was consolidated in 1981. And so it would be interesting to see where did Section 43 come from, when was it introduced, and what did the proponent of the legislation of that section give as its rationale, and if questions were put either in the lower house or the upper house, how were those answered? They within the constraints of what we all know is permissible, but I am happy if they would undertake that research, but Chair, I leave that to your discretion. I won't press it beyond what I have said.
No, I suspect I speak on behalf of my colleagues in saying that's an excellent suggestion. And if council would not be in any hostile objection to that way of proceeding, then we would be very happy if you would be willing to undertake that exercise. The appellant?
We will consider it an honor, sir.
Yes. First respondent?
I have no objections, and I look forward to hearing how Sir Richard addressed the matter at the time. I wouldn't expect him to remember all these decades later.
Second respondent.
President, if I may?
Yes, of course.
President, I wonder if you would direct that perhaps the appellant should do it so that we don't have multiple documents coming in with the concurrence of all council present a single memorandum on the matter. Thanks.
That would be fine. Justice Damodar, is that what you had in mind, or did you want to have their interpretation as well of the documents which informed the passage of the legislation? You simply want
I think this is just narrative. You know, if they identify the Hansard and the parts, the relevant parts, and it's left for us to do what it may say something, it may not. You know what I mean? So their interpretation is not necessary for my purposes, but the research is what I think may be helpful.
Okay, so we will put the onus on the appellant. And we will ask for that research to be done. I'm sorry. There may be some steps that the court naturally will have to take if we're seeking to get the report of the Parliament. But if there are steps to be taken, then of course we will do that. What sort of time frame are we looking at here, Mr. Cornell? Couple weeks.
Your Honor, I see ourselves having to place a better reliance on Sir Richard, as my learned friend Mr. Pisa was hinting at. He may have been in Parliament when this all was happening, and I'm happy to work with my colleagues. The Hansard doesn't lie, so our position in this endeavor would not be a personal approach based on the parties we are representing, but just looking to provide this honorable court with what the climate was like back in 1983. So I'm happy.
So as not to attempt to test the memory of Sir Richard, what I was trying to get at is the process by which we would obtain the report. And I was trying to figure out how long do you think that process, individually or collaboratively, would take?
Your Honor, if I may, the Clerk of Parliament is very responsive to requests. However, right now we're in the middle of the estimates exercise. So if we could take that into account as we set the time frame, I have no difficulty reaching out to him. He answers immediately, but he may not be able to deliver immediately given his workload for the time being, and I believe for the next 2 weeks. This week we'll finish in the House, and then it moves to the Senate for 1 week.
It's entirely on you, I know, but could you just then give us a ballpark? 3 weeks, 4 weeks?
I would say 4 weeks to give him the time to pay attention to the request.
Okay. Any objection? Justice Rajnath Lee, I thought you might have been saying something. No?
No, Chair. I thought that would be the time that would have been sought. 4 weeks,
Wonderful.
given all that Mr. Pisa said. Thank you.
Yes. And Mr. Thornhill, that is fine with you as well.
Fine with me. We can take counsel from Sir Richard on this as well, if he thinks we can do it. He, like he said, Your Honor, he must have been in Parliament at the time. But if 4 weeks, we can work towards 4 weeks.
Okay, wonderful. Yeah. And we will embody that in an order. Was that your intention, Justice Ramadan?
Not necessarily, Chair. I mean, if they undertake to do it as research, I'm good with that. They're all reputable counsel and reliable. So I don't think we need an order. I think they're going to undertake to do it. So.
Okay. And again, we are thinking of 4 weeks from today. So we look forward to hearing from you. Thank you very much for that intervention, Justice Contact. And again, thank you, Counsel, for this very interesting case. We will alert you once we have a decision for you. Thank you again. Madam Deputy Registrar, would you close the proceedings, please?
Thank you, Judge. Do you wish me to adopt the sentiments of counsel, or I can just go ahead and end the court?
You could just go ahead, please.
Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. And thank you, Madam Justice Ononuru. Thank you, Counsel. And a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.